Hi, this is Josh Blackman, and welcome to the 2023 Harlan Institute Ashbrook Virtual Supreme Court competition. Today, we're arguing the case of students of fair admission versus the University of North Carolina. This is the round of 8, and we are on match number 4 of the day. For petitioners, we have Alex Chen and Forum Shah, and for the respondents, we have Colin Young and Aaron Strauss. Petitions begin whenever you're ready.
Yes, Your Honor. Mr. Chief Justice, and may it please the court. My name is Forum Shah.
And my name is Alex Chen.
And we represent the petitioners and students for fair admissions versus the University of North Carolina. To briefly restate key facts, in 2014, petitioners sued respondents, the University of North Carolina, for their use of race-conscious admissions policies, which petitioners believe to be in violation of the Equal Protection Clause of the 14th Amendment. As it stands, underrepresented minorities at UNC may receive plus factors to their application on account of their race. These pluses improve a student's chances of being granted admission into UNC. Evidence presented at trial in the district court demonstrates that race is considered at every stage, from recruitment to evaluation. Academic achievements, such as SAT scores and personal qualities, are qualified based on a student's race. UNC rejected race-neutral alternatives in the district court, such as the modified Hawksby simulation and various percentage plans. This court granted certiorari in January of last year.
Your Honor, UNC's use of race-conscious admissions practices is an unequivocal violation of the Equal Protection Clause and of Title VI. This court should rule in favor of petitioners and therefore overrule Grutter v. Bollinger for 3 primary reasons. First, Grutter, the precedent that UNC's practices rely on, is inconsistent with this court's decision in Brown v. Board. Second, based on principles established in Ramos v. Louisiana, Grutter bears the hallmarks of a case that can and should be overturned. And lastly, under application of strict scrutiny, UNC's current practices do not even survive to begin with. In Brown, this court rejected the right to use race as a factor in affording educational opportunities. It enshrined access to education on equal terms, and it concluded that public education must be considered in the light of its full development and present place in American life.
Okay,
in the present,
Counselor, if I could just interrupt you for a moment. I realize you're asking us to overrule Grutter. You're asking us to overrule Bakke perhaps as well. In recent years, the courts overruled a lot of precedents. Last year, we overruled Roe, we overruled Casey, we overruled the Lemon Test, we've overruled case involving labor unions and a host of other cases. At some point, isn't there a legitimacy crisis when this court keeps overruling precedents every single year simply because there are new members in the court? As Sandra Day O'Connor said, we would not be overruling Grutter, but we are.
Your Honor, the way our constitutional government is formed, this is the way that the law is introduced and the way the law is
I get it. And look, you and I can make arguments about the law, but the people, right? People sitting on a college campus who are not lawyers, who are studying math or biology, how are they supposed to understand that a right they've relied on for half a century, affirmative action, is now gone, right? How are the people supposed to deal with this sort of issue? Doesn't it make us look political?
Your Honor, it would not be profoundly disruptive to overrule Grutter because there are various race-neutral alternatives that will fulfill these interests as well.
But California says we can't. Look, they come in with briefs a mile high saying that they've tried it, they failed. All these other states are saying we won't be able to do it with socioeconomic status. We just say they're lying, that they're making it up, that they're not telling the truth.
No, Your Honor. The way we are supposed to deal with this is by following, so long as we have a system to follow by in the court, the public should essentially abide by it.
Right, but you know, that's telling you submit because I am Zod, right? You know, I was watching Superman, right? You know, just that we're all powerful and you have to follow us because we're there. Isn't there something to say that people follow the courts because we're considered legitimate, that we're not a partisan body?
Yes, Your Honor. I mean, throughout this court's history, it is swung left, it is swung right, and yet every time we maintain the legitimacy of this court.
Okay.
Can I ask a follow-up question? So I wanted to follow up on what you began with, arguing that this is inconsistent with Brown. So I'm not necessarily adverse to that argument, but that's not our standard. Our standard for overturning cases isn't just that the things are wrong, but they must be egregiously wrong. And what I don't quite understand is that in Brown, we cited ample sociological evidence, lots of it quite wrong, but cited it nonetheless, for the proposition that we were not just just de jure discrimination, there was de jure subjugation of the races. So I think you could read Brown understandably as an anti-discrimination case, as you're pressing us to do and suggesting there's no affirmative action permitted. But I think you could just as reasonably read Brown as an anti-subjugation case. And I guess my question is, if our standard is that it must be egregiously wrong, how can you forward a position of Brown that is therefore so bad that it meets this high standard that we set recently in Dobbs?
Your Honor, I would like to direct your attention to two things. First, Brown established that we should evaluate education in the full light of its development in American society. When we look at it this way, it is clear that this practice of giving a plus to members of certain races becomes an inherent negative for other races, which has a significant effect in this hyper-competitive college admissions environment. And secondly, what is so egregiously wrong about Grutter is the fact that its base assertion that the educational benefits of diversity are compelling interests. Based on this court's precedent in numerous cases, this court has said in McLaughlin v. Florida that compelling interest must be necessary to the accomplishment of governmental goals. So much so that in Palmore v. Sadati, this court said that considering race in the protection of children is not a compelling interest.
So,
In Johnson,
Justice Watkins, go ahead, please.
I would like to ask you, ignore for a moment this court's precedents and look back to the original understanding of the 14th Amendment. Is it your understanding that the people who drafted this amendment did not use any kind of race as a factor in the legislation of the Freedmen's Bureau or the other practices they did shortly after this amendment was enacted? And if they did so, how does that influence your interpretation of this amendment and its understanding?
Your Honor, certainly. The framers of the 14th Amendment and the legislation that followed it did consider race in many ways. However, their racial consideration, their race-conscious legislation, was in the light of remediation. That was their primary compelling interest. If we look to today's current standards for how UNC is operating, they are claiming the compelling interest of diversity and the educational benefits that flow from it.
What about those people that think that the harms of racism in the past are still felt today? Couldn't they seek remedial things today as well?
We would be looking for a concrete, provable basis that broader societal remediation is necessary for giving pluses to underrepresented minorities, which we don't find there to be.
Let me, if I could do a variant of Justice Watkins' question. We'll stipulate that there were racial preferences in the 1860s with the Freedmen's Bureau Act, and maybe you might argue those were remedial in nature. But so what? Just because they need to remediate in the 1860s, does that mean they're forever limited to that scope? In other words, let's say the 14th Amendment authorized both remediation and other stuff. In the 1860s, they did remediation, and then later we did the other stuff, right? Who's to say that we're stuck with what they did in the 1860s forever, that was the outer bounds of what's permissible now?
Your Honor, we do not find that to be the outer bounds necessarily, but we find it to be a false correlation to make the comparison to 1860 and today. We don't find that bearing to be particularly persuasive. Of course, as society changes, as America changes, we have new compelling interests and new ideas for what could be potential race-conscious legislation. But making that correlation between 200 years is not.
Isn't there reliance at some point? If for half a century universities have been told, yes, you can do diversity as a plus factor, right? Justice Powell made this point in the about the Harvard plan back in Bakke, right? How are we upsetting university policies nationwide?
Your Honor, overruling Grutter and saying that race-conscious admissions policies are unconstitutional would not be profoundly disruptive, as many other colleges have done this. And furthermore, in Gratz, this court has said that the fact that the implementation of a program might present administrative challenges does not render constitutional.
So maybe we can just say that the university is not complying with the Grutter standard and leave Grutter in place. Maybe if what UNC is doing is so egregious, as you say, maybe they're not doing +1, maybe they're doing something else, and we can just leave Grutter in place and just stop the UNC policy. Can we do that?
Even if we were to implement the standards that Grutter established, that bear the hallmarks of what a narrowly tailored plan would be, basically all of the modern universities would fail that test. Grutter established essentially a two-pronged hallmark. One, that race will be used as a plus factor only, as Justice Powell's opinion in Bakke stated. And two, that race will be used alongside other factors. If we look at nearly every single university in higher education at the elite level, none of these are being abidden by. Essentially, what we're seeing is that there's no such thing as essentially an only plus
All right,
factor.
so Counselor, I have to tell you, right? What do we say to all the minority children that are going to be denied entrance to UNC because we rule against them? How do we look them in the face and tell them that?
Your Honor, these minority children would not be denied admission. There are various race-neutral alternatives
There'll
that
be
can
fewer
help them.
admitted. Every number says that there'll be fewer Black students in the entering class. We can say that with a high degree of certainty. You may finish.
Your Honor, even sorry, I apologize. We would tell them that there are programs in place that will help them get into universities, that are helping them get into university, and this small decrease cannot justify this consideration of race that permeates through American society with an unlawful use of race.
Okay, Counselor, thank you so much. Okay, if the petitioners or respondents, I'm sorry, can please come on camera, and we will begin whenever you're ready.
Yes, Your Honor.
Proceed.
Mr. Chief Justice, and may it please the court. The University of North Carolina respondents are the oldest public university in the nation, and throughout its history, the university's admissions programs, like those of most universities in this nation, have consistently hurt African American students who were barred from the school altogether until relatively recently. This history gives the university an understanding about the importance of racial diversity in institutions of higher learning. And to this end, the university uses a holistic admissions process that includes race as a factor. Petitioner today mentioned Brown v. Board of Education as an important case in this court's jurisprudence with regard to race, and respondent agreed. Brown v. Board of Education was an important step in expanding, including minority groups into broader American society, allowing them to participate in society. And in the same way, UNC's holistic admissions process, like many other universities, do the same thing, allowing minorities into society. It was Justice Stevens who accused this court's jurisprudence of, quote, disregarding the difference between a no trespassing sign and a welcome mat. Respondents today asked this court to recognize, as Justice Stevens did, that an attempt by the majority to exclude members of a minority from race is fundamentally different from an attempt that enables a small group of minorities to enter society. Specifically, this court.
Do you believe Asian Americans are one of those minorities as well?
Your Honor, as we will mention we will shortly mention, our standard is that discrimination against minorities should be treated differently than discrimination against the majority group. We believe that we should treat the group that's being harmed as a whole, and that would be white students as well as Asian students, as every statistical analysis shows, and that group taken as a conglomerate, which is the appropriate way in our view to take this, is not a minority group, and therefore should be treated as discrimination that benefits minorities as opposed to discrimination that harms minorities. So
well, let me follow up. I'm sorry, counsel. Let me follow up on Justice Watkins' question, please. Right, in any given class, there's a fixed number of seats, right? Bakke recognizes if there are 100 seats in an entering class, and you give a benefit to people with one race, you're necessarily depriving other people of that race. And to make this complex more analysis, race is difficult. Race is complex. I mean, you might have a person who's a first generation Nigerian immigrant who came to this country when he was 18 years old, who comes from a wealthy oil family, who will be treated differently than a white kid who grew up in Appalachia who had no benefits of any privilege. So, how do you possibly say we help the ones that we like the ones that benefit, but not the ones that hurt? It seems to all just sort of jumble together.
Your Honor, this can be justified by the fact that we're not using race to address societal inequality. We're using race to have racial diversity. So it's true that because of the way society is today, people with different races will have different racial understandings of themselves. And as we said before, racial understanding is more than just a box. It's more than just Black or white or Asian or Hispanic. It has multiple different aspects. So for instance, the Nigerian immigrant would have a special relationship to his race and race in American society, that perhaps an African American would have a different understanding of race, and all of those understandings.
And the white kid from Appalachia would not have that understanding, or first generation Taiwanese immigrant would not have that understanding?
We believe that they would have their own unique understandings, Your Honor, but we believe that in the current, the way academic achievement is in the United States, those students do not need a boost from the affirmative action
Why?
programs.
Why would the first generation Filipino immigrant not need a boost, but the first generation Nigerian immigrant would?
Because statistics, as we mentioned in our brief, consistently show that those groups actually outperform other minority groups and therefore don't need the help to have diverse representation in our student bodies. Your Honor, furthermore,
I got a question. How do you determine what is a majority group? I mean, in my mind, white you may think of as a majority, but white is made up of a lot of subgroups. You got Irish, you got Italians, you got all kinds of different groups, none of which on their own is a majority. So the only way it seems to me that you get to a majority is by merging these groups. So how do you determine which groups should be merged and which shouldn't?
Your Honor, again, this is where we reference statistics about which groups are being benefited versus which groups are being hurt by societal disparities. In this case, again, as we said, there is a conglomeration. While there are differences within the white conglomerate, within a white conglomeration of people and the Asian conglomeration of people, the fact of the matter is they are benefited, but they do not face the disparities that those Black individuals in a Black Latinx that affirmative action is benefiting are hurt.
Can I? Okay, I want to take us in a slightly different direction because I'm struggling with something that you continue to say, that you have a holistic process, right? Like a holistic, like race is one of the things that you consider, but not everything. What I don't understand is why race is always compelling. Like that doesn't make a lot of sense to me, and I think this builds on Justices Blackmun and Walton's what they're talking about. Because what I don't get is, like, in some situations, sure, race could be very compelling if you're sitting across a classroom from someone of a different race than you. But in other senses, as we're exhibiting now, you might be in a classroom on Zoom where you turn your camera off and I literally can't see the race of the student who's speaking. So I don't understand why your position is that student body diversity is always compelling, when I think it's clear that in some situations you can't see students' bodies.
Your Honor, if you don't believe that student body diversity is a compelling state interest, our argument is actually that this court should apply intermediate scrutiny to this circumstance because it benefits a minority group, and therefore we would only need an important government interest, which we believe is fairly clear that student body diversity would constitute at least an important government interest.
So I understand that. I mean, is your argument, though, that it should be a fixed level of scrutiny? Right, that like no matter what the case is, whatever, if we're doing racial admissions, race-based admissions in higher education, we're going to set one level of scrutiny. It's that no matter how frequently you can see student bodies at your campus, no matter how much you consider race, like why shouldn't the level of scrutiny itself be a fact-specific inquiry?
Your Honor, we believe that it's because any given level of scrutiny allows for a lot of fact-specific inquiries within those levels of scrutiny. So, for instance, the fact that it's a remote campus or you can't see other people would make it less likely that the government would have an important government interest, for example, as compared to an in-person campus. So the reason is because we believe that levels of scrutiny already allow for that.
What about some type of narrow tailoring? Do you think that that should be applied here? And if so, what about applying some kind of race neutral means of promoting and allowing these minority students to get into colleges? Why shouldn't that be done instead?
Your Honor, we contend again that intermediate scrutiny is the standard to be used here. So that means that the law must use a method that is substantially related to an important government interest.
Just to be clear, I mean, the court has rejected your approach of using intermediate scrutiny for ameliorative racial uses. So you're actually asking us to overrule some precedent, aren't you?
Yes, Your Honor.
I mean, so isn't that put you in a weird spot? I mean, you're saying don't overrule Grutter, but you should overrule, I guess, Adirond or some of the other precedents from the 90s. Isn't that sort of put you in a weird box?
Yes, Your Honor, but we are confident in our position because we believe that the precedents that we're asking to overrule on both outside of this context and in the school affirmative action context don't have reliance interest. So for instance, changing the rationale for Bakke and the rationale for Grutter into saying that we're actually going to change the standard to intermediate scrutiny would still protect affirmative action, and therefore it wouldn't disrupt any reliance interest, which is the basis of stare decisis.
What about those schools that believe they don't have enough white people? You know, white people are 70% or whatever percent of the population, and they are at 50% white people, or substantially less white people than there are in the broader population. And they believe for diversity's sake, they should have more white people. Why shouldn't that be allowed?
Your Honor, again, this is where the difference between minority and majority groups comes into play. The white conglomeration of white Americans and Asian Americans forms a large conglomeration where they are the majority.
I'm sorry to interrupt you, but these numbers fluctuate, right? 30 years ago, maybe the numbers of Blacks, Hispanics, and Asians was different than they are today. These things aren't fixed, and the sort of jurisprudence you're asking us to adopt creates a permanent debtor-creditor race, which is what we're not supposed to be doing. I mean, the way you're talking about these classes may make sense from a sociological perspective, but we're writing a Supreme Court decision. We're going to say, yes, these races are worse off, we should give them special benefits, lock them in, right? And that just seems so antagonistic to who we are as we're all Americans.
Your Honor, on the contrary, we don't think that it's our jurisprudence that's doing that, but the actual effects of discrimination that are doing that. So if it were the case that, for instance, Black students and Latino students were to outperform white students and Asian students in the future, then our jurisprudence would have the flexibility to allow schools to readjust their standards. Now, it's true that
how on earth do we administer that? Do we really have to come back every couple of years with every census or with every new round of social science data to tweak who our debtor and creditor races are? I mean, is that really what we're going to have to do with your test?
Your Honor, we believe that intermediate scrutiny has a built-in time limit. If there is no longer any racial disparity in terms of academic achievement, then using race would no longer be necessary.
How long have we been doing this?
Justice Watkins,
how long have we been doing this affirmative action so far? I mean, if there's a time limit to this, why haven't we reached it already?
Your Honor, although we can't answer the question of why the underlying causes are, the surface level causes that we can't stop affirmative action is because those disparities still exist in large part, as we've just demonstrated in the statistics in our brief.
Well, so you think there'll be some point where we don't need affirmative action, where you think we'll hit that point?
We're confident that with the development of inclusion of different races into society, that we will eventually hit that point.
So at that point, then we can get rid of all racial preferences.
Yes, Your Honor. That they would no longer be necessary for an important government.
Let's pivot to talk about law for a bit. The question, okay, so I think we all agree the Supreme Court said remediation is okay, and you agree with that. You can use race to remediate past discrimination. Affirmative action has always struck me as an outlier, that usually compelling interests are super high, then you have education diversity, somewhat whatever, right? Do you think that Bakke and by extension Grutter were deviations from the court's precedents like Adirond and City of Richmond v. Croissant?
Your Honor, could you clarify in what respect you are asking the deviation?
Are you familiar with City of Richmond v. Croissant and Adirond?
I'm familiar with Adirond, yes, Your Honor.
Okay, so I mean, Adirond suggests that you can only use racial classifications to remediate past discrimination, right? That's the only way it's used. But Bakke and Grutter seem to say there's this other little carve out just for educational benefits. Isn't Bakke and Grutter kind of a deviation from long-standing precedent?
Your Honor, we believe that Bakke is merely expressing the uniqueness of the educational context, insofar as higher education is where our military and our industrial leaders of the future are formed. Therefore, it's of extreme importance that there is a racially diverse
But aren't we
in
teaching
that
them
mix.
that their degrees are diminished in value? I mean, Justice Thomas has written about this at some length, that when a student is knowingly admitted under an affirmative action policy, he feels lesser as a person, that he was admitted because maybe he didn't even deserve it. Aren't we just breeding this ongoing sense of inferiority among minority students? Aren't we doing them a disservice?
On the contrary, Your Honor, we believe that we're giving minority students the opportunity to have one of the best educations in the world at a school like UNC that otherwise they wouldn't have access to. And we believe that that's a priceless benefit of a program like the holistic admissions program at our university.
I got a question.
Could I ask you to briefly address something that your co-counsel addressed? Your co-counsel or your opposing counsel seemed to argue that the original meaning of the 14th Amendment didn't support their view. I was wondering if you could comment on the original meaning of the 14th Amendment and whether it supports your view, opposes it, or doesn't affect it in any sense.
Your Honor, we'd actually contend that the framers of the 14th Amendment, as many of them worked on the Freedmen's Bureau, did not intend for the petitioner's extreme interpretation that race never be used as a factor in a government program, we'd say that many of those framers of the 14th Amendment, due to their involvement in the Freedmen's Bureau, would actually say that race is an important factor, especially when it benefits a minority, as the Freedmen's Bureau and the 14th Amendment were initially intended to benefit those racial minorities, specifically Black individuals.
So I've read the debates that occurred when the 14th Amendment was adopted, and they repeatedly attacked the idea of class-based legislation, that different people of different classes should be treated differently in that manner. Why shouldn't that class-based, and it seems to me you're supporting or encouraging the class-based legislation that they were outspoken against. Do you dispute that, or do you disagree with my understanding of the debates?
Your Honor, we'd actually say to the contrary, that according to the framers of the 14th Amendment, it was derived that all persons within the jurisdiction of the United States shall have the same rights as are enjoyed by white citizens. Senator Trumbull, who was instrumental to the crafting of Reconstruction era amendments, said that the law is for the relief of the persons who need the relief, not for the relief of those who have the rights already. The Freedmen's Bureau Act directly gave benefits to Black individuals in social and educational contexts. Congress, for example, created schools specifically for Black people called Freedmen's Schools, monitor Black labor deals.
Justified in the 1860s, we're now in the 2020s. How are those steps still justified?
Your Honor, as we can see there, the racial disparities seen then still persist today, as shown by the numerous statistics.
We're talking about differences in education versus lynch mobs hanging people on the street. Are these the same sort of disparities you're seeing?
Your Honor, well, we believe some of the extremity of the disparities are different. The disparities in some contexts still persist, especially in the educational context. There were disparities in education then, and there are still disparities in education now, as shown by the numerous statistics.
Thank you so much, Counsel. Thank you. Petitioner, you have 5 minutes rebuttal, and you can begin whenever you're ready.
Thank you, Your Honor. Your Honor, respondents' arguments split an unconstitutionally fine line with a majority-minority conglomeration argument that creates stereotypes based on statistics. They contradict this court's entire understanding of judicial scrutiny as well. It is groundless and unsound to apply intermediate scrutiny under this court's precedents. This court has repeatedly affirmed that racial classifications warrant application of strict scrutiny no less than 13 times other than just.
You're asking us to overturn our precedents in the past, and they're asking us to overturn our precedents. Why should them being contrary to the prior precedents be any different than your arguments that are contrary to the prior precedents?
Your Honor, their arguments would fundamentally shake not just a real world not just be profoundly disruptive to the real world, but be profoundly disruptive to our entire jurisprudential understanding of scrutiny and heightened scrutiny.
If I may add to that, Your Honor, as Justice Blackmun brought up in their round, Adirond v. Pena clearly stated that all racial classifications must be evaluated under strict scrutiny, and therefore it would have significant consequences, and it would upset reliant interests way more than overturning Grutter for the petitioner's sake, for their asking for intermediate scrutiny to be applied. And although they argue that since it's a majority group and they're not being harmed, in the city of Richmond, this court's opinion stated that the application of strict scrutiny is not dependent on the race of those burdened or benefited by racial classification. So it would have a significant upset of reliant interests.
Do you think if we did apply intermediate scrutiny that the university's policies would meet that?
Your Honor, petitioners would concede that should this court apply intermediate scrutiny, it is likely that UNC's positions or practices will comply with intermediate scrutiny standard as this court has interpreted.
And that is why we insist that the application of strict scrutiny to racial classifications should not be overruled because of how grave the matter of race is.
Can I ask you a question I did not get to ask during your initial responses? So there's an amicus brief that bothered me here. So there's an amicus brief submitted by the Association of American Medical Colleges, arguing that diversity in medical education markedly improves health outcomes. And where else do we get our doctors in med school but from undergrads like UNC? So is health outcomes, is that not a compelling interest?
Your Honor, while we believe that the primary objective should be race neutral, and I am not an expert on this, but I do not know if medical schools have applied race neutral alternatives yet, or have they tried them.
We're
However,
trying the same as UNC is. Yeah.
There are plenty of race neutral alternatives that could be similarly effective, just how this would not affect our military academies.
Yeah, but counselor, look, do you really want Black people to die because they don't have doctors that look like them? Is that what you want to happen?
No, Your Honor. We do not believe that that's going to be the outcome.
But like the brief that Justice Nelson mentioned, are you doubting or saying these doctors are wrong, that the brief has errors?
No,
We
Your
are-
Honor. Oh, sorry. We are simply suggesting that if these race neutral alternatives fail to work,
But they
then
say they can't work. But okay, how many people have to die before we revisit this decision? Let me put the question differently.
Your Honor, if minority enrollments drop to precipitously low numbers, precipitously low, as in it would harm American society as
But
it
look,
stands.
med school is a 7-year pipeline. I mean, how many years you have to go to med school plus residency? We're gonna take a while to figure out how this shakes out, right? So how many people have to die for the next 7 or 8 years to even have to come back and fix this? Precipitously low.
Your Honor, if the medical school can prove at a statistical and concrete level that they have a compelling interest other than diversity itself to reduce these deaths, then we would concede that they could have.
Oh, so you think a med school could admit students explicitly on the basis of race in order to help improve health outcomes? This goes to Justice Nelson's question a moment ago.
If they can concretely prove that the health outcomes would be a compelling state interest.
Okay, so that's
What kind of
medicine. What about a less rigorous major? Sorry, what about like philosophy or something? I'm sorry, not to be facetious, but you know.
Your Honor, philosophy would. I do not see a potential
Don't
situation
answer
where
that.
philosophy
Justice
would
Watkins,
be.
don't answer that. I don't want to offend the philosophy students.
What kind of evidence would you require to prove that there was that kind of sufficient evidence?
Similar evidence that is currently being provided to this court that show that there are significant negative real world or jurisprudential effects, as this court held in Ramos v. Louisiana, would suffice to prove that that would be a compelling government interest. It would be under this court's discretion to interpret that, yes.
Okay, counsel, I think you're just about out of time. All right, we'll wrap it there. All right, the case is submitted. Thank you so much. All right, both teams come back in camera. No one wants anyone to die, I promise.
One thing.
What's that?
My partner had to run. I'm sorry.
Oh, that's okay.
Yeah.
Is he all right?
Yeah, he's doing all right. He just forgot he had a test.
God, he had a test. My goodness. Oh man, now you won't get to college. Oh, it's gonna be devastating. Well, first, let me be the first to congratulate you. That was a very tough round. I think the teams were actually pretty well matched. You both did really well in the opening rounds, and as you can tell, we really ramped up the questions. And I tried to do a couple things. I'm sure you're aware of it. But one, I tried to build on my colleagues' questions. I would always refer back to Justice Watkins and Justice Nelson. And when you're on a multi-member court, you have to think about that very carefully, right? It's not a one-way conversation, it's a multi-way conversation. And I often view oral argument as like a dialogue with 3 or even 9 judges and 1 or 2 or 4 advocates, as it were, across the entire stretch. And a powerful thing you could do is when you're answering a question, say, well, you know, Justice Blackmun said this a few moments ago. I think Forum did it a couple times. That was good. And pay attention to what happens when the other side's up. That's actually very useful to do it. I also tried to make you flinch, where I would just say completely outrageous nonsense. Like, do you want people to die? And you might think, who would ever ask that? But look, you go to some courts, you'll get questions like that. Justice Sotomayor is very good at asking very personal questions that cut to the heart of the issue. She's very effective at this. And you have to basically say, you know, how you look at these minority children, say you can't go to college, right? You know, these are things. I also tried to give you line drawing questions. I like the line that Justice Watkins was asking about the med schools and how do you have concrete evidence. That was actually, I think, a good colloquy because you actually gave some ground. And I think you actually giving ground helps you in the end. Maybe Ryan and Devin disagree, but I think giving ground makes you look more reasonable. This poor philosophy
does, but it makes it more difficult for some of the lower courts to figure this out, and assuming that we rule in your way, of course.
Yeah. But the overall, I thought you were all very strong, very effective. I'll give some more concrete feedback in a minute. I want to make sure Devin and Ryan can comment as well. But I have to remind myself that you were all law student, high schoolers. You're not in law school. They treat you as if you were a law student because you could walk in tomorrow to a law school and be a finalist in the championship round. You're that good.
Yeah, I echo that feedback. I think that's fantastic. So some of the things that struck me that I thought were excellent on both sides, your specific citations to uh, facts and case names bring it home and make us remind us that we are indeed a court of law and not just a court of policy decisions. So for petitioners, you cited, for example, the modified Hawksby test. I think 4 of you did that. Love that. And then you cited Palmore versus Sadati. You cited all these case names. We're talking Adirondack. Anytime you ground your argument in a fact or in a law, it forwards it. It makes it much stronger. And similarly, on the opposing side, you cited Senator Trumbull. You cited Adirondack by name. You cited all of these very specific things. That's great. That really grounds your opinion in a source that then the judge can look up, which is excellent. So again, well done to all of you. I think this is a fantastic exercise. Go to law school.
Devin, you have some thoughts for the students?
I thought you all did an excellent job. I've talked to many people. I talked to people earlier today about court cases that I'm involved in, and working through them, and it takes a long time before they come 1/10 of what you have of the understanding of this case. So I am very impressed with what you've accomplished in being able to understand all the complexities here, because this is definitely not one of the more easier cases to handle.
Oh, can I add one thing for both sides? So I don't know that it's a great idea to try to even engage with intermediate scrutiny as an argument. I feel like it's biting off more than you need to chew to try to argue that, because when you go down that road, and then I think it opens up a can of worms that are bad for both sides. On the petitioner side, I don't think you should concede that you would lose under intermediate scrutiny either. I don't think you should concede you'd lose at all.
I wouldn't have expected that when I asked the question. I was expecting you to say the other way around.
Yeah, but that's on the other side too. I don't think you should engage with intermediate scrutiny. I think you should just say, like, look, that's it's not presented. Right, the question isn't presented before the court, so if the court desires briefing on that, we can deal with that
Ryan,
later.
part of the thing is they have a brief, and that's what they argue in their briefs. They're somewhat stuck with it.
I see. So then you have to then.
Yeah,
okay,
and in fairness to Colin Aaron, they actually asked me, could they make that argument? I said, yeah, it's your argument. You can make it in your brief. So
then that's fair. So then, I don't think that it's like unreasonable to argue. I think be cautious with the argument of saying, well, then if it applies, we definitely lose. I think you can just say, like, look, you can't consider race at all as on one side, on the petitioner side. Doesn't matter what level of scrutiny applies, you just can't consider it at all. And on the opposing side, intermediate scrutiny, great. Who cares what level of scrutiny? This is compelling, so it certainly is significant.
Yeah.
So you can definitely argue that it isn't a significant interest, and so it wouldn't even meet intermediate scrutiny, I think. Or there's a variety of other ways to do it. You can probably just avoid the question that happens a lot. They say, Your Honor, that's not this case. We have precedent that needs to be considered.
Maybe even like frame it as an alternative argument. It's like, we think we win under strict scrutiny, but if the court disagrees, then maybe we should consider going to intermediate. Like, so that way you're not leading with intermediate. They gave the same feedback last time, and I feel sort of bad, but let me put it this way.
I think it's reasonable to mention it.
It's a reasonable position, and then you stuck to your guns too. You were able to articulate why. Now, the difficulty, though, is you get into this question of the debtor and creditor race, and you sort of open yourself up that there's some races that are advantage and disadvantage, and that won't work well with some of the judges. On the current court, if you walk into that, Justice Thomas would probably lean forward in his chair, just glare at you. I would give you a medal if you pulled it off in front of him. But it's a strategy. If this was Thurgood Marshall in his chair, you damn sure make that argument. But this is Clarence Thomas. You're not making that argument. Just as constructive feedback forum. So I saw you last year. I didn't see you in the first round. Try to keep your hands on your desk. You talk with your hands a little bit, and there's difference of opinions. I find it distracting, and people don't mind it. I find it a little distracting. And also, I noticed you got a little excited at points, and you start talking faster. And it's something we all do. So just be aware of it. One thing that I do, because I'm from New York, I have it in me, is I often will pause, just take a little breath, and that just sort of resettles you. And just try it when you're practicing. Just take a little breath, and it works well. The handoff, the digital handoff was good, but there was a little bit of a latency, which I don't think was your fault. I noticed it pretty quickly that it's not that you were slow on the draw, it's just that there was a latency. So to the extent that you could two be seated next to each other if you advance, to try and make sure that happens. It's not required. During the COVID, no one was sitting together, but now I think we're allowed to do that. And for Aaron and Colin, I think Colin, you spoke a little bit more than your partner. Maybe it wasn't quite 50-50. Maybe that was my impression. I don't know, maybe Ryan and Devin disagree, but I thought Colin talked a little bit more. Gray suit talked more than blue suit, if I can use that. So just try to even out the load. It's tricky when you do this high school format. In law school, it's just 1-on-3, right? You don't have this partner thing. But if you have the balance back and forth, can be alternate questions or different strategies, that it just feels more balanced. That's just my only comment. But you all did exceptionally well. I don't want to take away from your hard work and your prep. I know you've done significant work. You're dropping Adirond, Lyman, Trumbull. My goodness, I didn't know who these people were when I was 18 years old. So it's very, very impressive.
Some of those briefs were really good too. I mean, I at first look at the brief, you got to kind of do a double take. This wasn't written by someone in law school or a lawyer. I mean,
yeah, no kidding. Yeah, no, it's very impressive. Do you have any questions for me or Ryan or Devin and about law school, about the case, or anything you want? We've all done work with civil rights stuff, and Ryan was a labor lawyer for many years, and Devin does public interest litigation in DC. So we maybe have a range of experience that we can help with.
Could I just ask a quick question about like the case / our sort of line of argumentation? So the initial rationale was that I looked at the case and we got respondent, and I'm like, I honestly don't think diversity is a compelling government interest. Like, I don't think that's the case. So what I ended up doing is, I don't know if I think I didn't communicate this too well in the brief, but I tried to say we win even though it's strict scrutiny, but our main argument was it should be intermediate scrutiny. Is there a way to communicate that, like I was trying to cram as much as I could into those like first 2 minutes to make it clear. So like, is there a way to do that?
I would have emphasized the strict scrutiny a lot more. It seemed like to me you were emphasizing the intermediate scrutiny. If you emphasize the strict scrutiny and then at the end you go, and even if you don't agree with me on that, that kind of thing, that's usually the better way to do it.
Yeah, that's why I said, like, lawyers often argue what they call in the alternative. It's like, here's my primary argument, but even if you don't agree with my primary argument, fall back on intermediate scrutiny. And if you frame it in that sort of alternative fashion, I think most of the judges will pick up pretty quick what you're trying to do. You were better this round than the first round. The first round, I got to admit, they were saying we should overrule Grutter. I'm like, what? And then I was like, oh, overrule the Grutter part about strict scrutiny. Like, it took me a minute to get it. So this was actually an improvement on the last one.
I think of it this way too, Colin. So like a lot of the time when I represent clients, I absolutely disagree with the way they want the law interpreted. I just think they're wrong. If I were the judge, I would come out to a different interpretation. But when you're an attorney, you have to make the argument that is best for your client. And the best argument for your client is strict scrutiny, compelling interest, if you can make it. And I think you can, in good faith, make that argument. So even though you don't agree with it, you curse it when you're at home, and when you're in court, you pound your fist and say, this is absolutely correct. And then if you have to, Your Honor, go to this, horrible secondary opinion of intermediate scrutiny that, when we go out afterwards and talk about it, it's what I actually want, that you could do. But think of it in terms of the right answer is not what you believe the right answer to be. The right answer is what you believe your client believes the right answer to be, and you can defend.
I should say, it depends on the type of lawyer you are. For most lawyers, that's the case. They take people in, they represent them and try to put forward what they think is the best legal argument for them to win. My kind of attorney, I'm working a nonprofit. My role is to develop what I think the law should be and go find clients to go litigate those positions. So it's kind of an opposite way of looking at the law, but
but yeah, both are really useful. And when you all go to law school, you get to choose and maybe do both.
Yeah, you don't have to take a client. Most people do it for money, but if you're what we call public interest litigation, you generally take cases that are on one side of the angle, one side of the aisle, so to speak. And that's what Devin works in his profession. I pick my clients. Law professors, Brian too. Now he picks his clients. So, but even if you pick your client, you don't always get to pick your arguments. And no matter what representation you're in, you may be backed into making an argument that you don't like very much. And you have a zealous duty to represent your client. It's an obligation. It's not something you can do. You can drop at a moment's notice. And look, sometimes you make an argument and you hold your nose and you sort of live with it. And look, I'm not blind to the fact that I have 4 Asian Americans sitting in front of me arguing about this case brought by Asian Americans. I'm not blind to that fact. It's just the rounds shook out that way. That's how the match lined up. And look, you're making arguments that affect you personally. You were all high school juniors and seniors applying to these elite institutions, for which you will, probably be disadvantaged under the current regime. But look, next year it'll be a different regime, right? So I'm not blind to that fact. It's just sort of how it shakes out with the rounds.
Actually,
Can I ask one? Sorry.
I have another question about our argument. I feel like we need to make, at a certain extent, some leeway, some concessions, and that medical question kind of got there. Do you think when it comes to the end of the rope, the very last where it's like, it's essentially having a harm on other parts of society, would that concession be reasonable to make?
What do you think?
You can say that if there is that harm, but I wouldn't concede the facts that are in that amicus.
I agree with
if
that.
I was up there, I'd be going, that amicus is wrong, Your Honor. But even if it were true.
I mean, so I reviewed the brief that, and by the way, Ryan's husband's a doctor, so I'm sure this is on his mind heavily. But I reviewed that brief. The delta, right, is actually very small.
Yeah.
It's actually a very small difference in health outcomes, which is well, so like 2 people die, right? That's the response. But
I think you're right. You don't concede the fact that it's correct. They're going to say, what, you don't believe doctors? And you say, well, first of all, we don't have doctors here. This is an undergraduate case. This is not medical school. This is far too attenuated to prove that level of causation.
That's right.
And on the other side, people will die. That's your argument, right? This will cause more people to die. And let's not just do mortality. It'll cause morbidity. It'll cause more problematic health outcomes. And it's not just the medical field, the engineering field. There will be bridges that are problematic. Make it, hell on earth. Everything is awful. And then pull it back a little bit because that's overly hyperbolic. But the point being that this does have downstream ramifications if you're on Colin's side.
Sure. And when you're asked, do you trust? Why don't you trust what the doctors say? Well, you say there are a lot of doctors out there, and they have a difference of opinions, and there's other doctors who believe different things.
I agree with that. I think that's a great, yeah. So I agree. Try to fight the facts, and then try to fight the law, and try not to concede either if you can't. But if you're pushed into a corner and you must, try to differentiate the case and say this is not that case.
I was trying not to fight the hypothetical as Mr. Blackman insists.
I advise him don't fight the hypo. That was actually the instruction.
You're going to do great in law school then.
Yeah.
You shouldn't, if the judge frames the question as a hypothetical, assume that this amicus brief is correct, then you have to follow that hypothetical. But if they just say, what is your thoughts on this amicus brief, or I was interested in this amicus brief, you can totally say, I think that amicus brief is wrong.
And look, even if you're not familiar with it, because there are like almost 80 amicus briefs filed, you're saying, Your Honor,
exactly.
We have doubts about that amicus brief, but even assuming it's correct, right? You could even remember the even if we said before, even if that brief is correct, it still wouldn't matter, and that's how you shake it out, because you're not going to know every amicus brief. The pile is this high. All the briefs in this case, it's ridiculous. I think
we'll see on my case. We just filed a quiz a couple weeks ago at the Supreme Court, so. We'll see how many amicus briefs we get.
Harlan, I think you had a question too. There's some crosstalk before. I'll make sure you get a chance.
Yeah. I guess my question was, is it tenable to, so I was trying for I understood the primary, secondary position thing. Is it tenable to hold the intermediate scrutiny as the primary position? Because I thought that, so we're saying it should be intermediate scrutiny, and obviously we win under intermediate scrutiny, but even if you don't think it's intermediate scrutiny, we should still win under strict scrutiny.
I don't think you can, and there's actually a pragmatic reason why. In order to ask the court to overrule a precedent, you have to ask them to, and that was not done here. So I am just, in the next round, I'm not going to be judging. It's me actually circuit court judges. Oh yeah, by the way, so the round of 4, I'm with 4 actual judges, and they're not going to know the sort of thread you're trying to needle, or the needle.
I mean, the stare decisis puts a big thumb on the scales in your favor if you're arguing that current precedent should be kept. If you're arguing that current precedent is wrong, and they're also arguing current precedent is wrong, it kind of splits the difference. And it's like, well, stare decisis is out the window. We just now have to evaluate this kind of on the merits and kind of 51% without reliance interests or any of that kind of stuff. So I tend to think that's the wrong way to go unless you really have to go that way.
I agree.
All right, any other questions? All right, awesome. All right, well, if the students
Great
can
job,
please
y'all.
sign off, I'll talk to the judges in a few minutes, but congratulations, you all make me very proud, and I hope in that 7 or 8 years I'll see you in law school, and I think you'll become members of the bar and you'll be very effective. Thank you so much.
Thank
Take
you.
care, everyone.
Thank you.
And
Thank
please
you.
say
Thank
something
you.
to Aaron. I'm sorry he had to run off to an exam.
Yeah, absolutely. Thank you.
Thank you, sir. Bye-bye.